Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Rebecca Melone with Melone Hatley PC, and welcome to I Now Pronounce You Divorced, where we talk about issues, cases, all kinds of stuff when it comes to divorce, custody, and all things family law. Today, I'm joined by Dan Cuneo, and we're going to be talking about some of the dumbest mistakes that we've seen clients make in going into a divorce situation. So one of the top mistakes that I've seen over and over again is when somebody just moves out really quickly. And they're like, I can't take it anymore. I'm moving out right now. Just a spur of the moment decision. Dan, what does that end up kind of looking like, or what sort of problems can come about as a result of just leaving like that?
Sure, a lot, right?
Yeah.
And what I mean by that is it's really going to depend upon jurisdiction because in some states, moving out, you may not be able to move back in. And in a lot of states, that's kind of like that demarcation line to where that's the date of separation, which is so important in those states that you have to be physically separated to where the statute starts running. And then there's a lot that you need to do before the court will dissolve the marriage, or there's a lot you need to do to make sure that you're protecting yourself. Because, for example, in North Carolina, you have to be physically separated for a year and a day. And what that means is once that magic day hits, you can file for an absolute divorce, which is just saying, judge, court, we've been separated for this requisite amount of time. Go ahead and dissolve my marriage. And if you're the party that needs support or wants to do some type of property distribution, it makes it a lot harder. And on the support side, if you have that absolute divorce, you're waiving your right to ask the court for some type of financial consideration or some type of financial support. And so you want to make sure that if that happens, you're smart about it. And I get it. You're right. Sometimes it's just like, oh, I just can't take this. I can't take living with him or her. And I just got to get out of the situation. If you feel that you're in harm, yes, by all means, we're not advocating stay in.
Right.
Get out, get help, talk to the police, call an attorney, make the record, and then move forward. But if that's not the situation, talk to someone before you move out because there are ramifications. And if there's children involved, then that's going to just further complicate that because what I've seen is I've had a parent move out for the reasons that we've been saying and discussing, but getting back in is hard. And then the parent's going to say, well, you moved out. That was your choice. You can no longer come back in. And oh, by the way, you can't see your kids. And they're going to argue to the court, he or she abandoned me. I didn't ask them to move out. They moved out on their own will. No one forced them to. And I was left all by myself. I have all these expenses, the child or children I have to take care of. It's just been me, me, me. But the other side is like, well, wait a second. It's because you made it intolerable to live with. I didn't want to create a situation to where the kids would be exposed to us arguing. So at the end of the day, that if it's unfortunate you come to that realization, talk to somebody before you move out.
Right. So the piece I feel like usually is missing is evaluating the financial implications, right? So if I just up and move out and I go and, rent an apartment or something like that, then end up being on the hook for paying for the primary residence and some amount of child support, and I'm trying to pay for the new apartment that I just signed a however long lease on, that's going to be a really difficult financial situation for anybody. And so I think all too frequently, it'll end up being the primary earner that's the one to move out, and they don't realize the financial ramifications of it. And then they end up getting kind of way behind in their case before they even really get started. They're so far behind, and you can't do things like order the house be sold immediately or something along those lines. So you're just going to be on the hook for all of these expenses as you're going into it. So one of the other mistakes that we find is choosing the wrong lawyer. And what do you think that kind of translates to, or how do you think that has an impact on the case?
Oh, that could have a detrimental impact because you want to make sure that when you're meeting with a lawyer, speak to them about what's going on in the case. Make sure that they have experience and not just in family law, right? But in the particular issues that you're having. If it's custody, ask a lawyer what their experience is in custody, what has been their experience with the court that you're in front of. You want to make sure that that attorney not only has experience in family law, not only has experience with the potential issues that are involved in your case, but also do they practice in that jurisdiction? A lot of times clients will hire an attorney and they have no idea what's going on in that courthouse. And that's not to say that they're going to get small town in the sense that smaller towns, there's a little bit more of a relationship between the attorneys and the judges because there's more of a general practice happening. There's a lot of rules that going on in each local courthouse, and each courthouse may have their own local rules. And if your attorney isn't familiar with them, that could have a detrimental effect on your case to where you could have pleadings that are stricken, meaning you're not allowed to present evidence on certain issues to the court, or your case may be dismissed. And so these are just factors that the court has to rely on because they're the local rules. But if your attorney doesn't know them, then it could have an effect. Also, courts will have what we call law day, where certain motions are heard on that day or certain status conferences. You need to know when those are and how to set hearings. And then you need to know who to go to as far as when you want to get in front of a judge. So there's certain procedural concerns that need to be taken into consideration too. But hiring the wrong attorney, it really, bigger picture, could have detrimental effects. You don't want to hire someone just based on price. You really want to do your due diligence to make sure that they are familiar with that type of law.
Right. And I think a couple other sort of layers to that. If you have somebody that does 90% criminal law and 10% family law, right? They've maybe done a case or two, but they're not necessarily going to have that experience. They're not going to have done those hundreds and hundreds of cases, and have that experience and that knowledge of what needs to be done with your situation. I think the other big sort of differentiator between different family law attorneys, some are very much more geared towards a collaborative approach or a mediation type style approach, where there's really no intention of going to court, or they can be a litigation focused attorney. And so you need to know going in, well, what do I need for my case? Is this likely to be a collaborative law situation? Or are we going to need to go to court? Because you don't want to go and hire a collaborative firm, spend a whole bunch of money, only to now turn around and now you need a litigation attorney, right? That can be a major mistake at the beginning of your case. Now your resources are going to be more limited going into what's going to be the ultimate, decision, the ultimate important part of the case. Now we also see some clients will come to us and they'll say, I'm just going to wait. The other side said they're going to file. I'm just going to wait for them to do it. What do you think is the potential negative of that sort of method?
I always feel like in these podcasts, I'm always answering it depends, but in the law, it really does because it depends on the jurisdiction. And some jurisdictions, it's not advantageous to wait because I'll tell you, at least in Missouri and Illinois, the courts are going to look at from the date of the marriage until date of divorce. And so if you're waiting for your spouse to file, everything that you're potentially accumulating is a marital interest. I say potentially because there's certain factors to where it could exceed that and it may be premarital. And this goes back to your comment earlier. You want to make sure that you're talking to someone that knows that because there's so many nuances when it comes to this practice of law. But there are other jurisdictions to where, and I mentioned it earlier, talking about North Carolina, that from that physical data separation, anything that you're potentially acquiring could be your separate interest. And so your spouse would get an interest in it. Now there's extenuating circumstance because it depends on what you are acquiring and what it kind of relates back to. If it's something that you had an interest in before the marriage, there could still be some type of marital component to it. But it's really, filing is all about timing in the sense of what are you looking for to protect your finances? What are you looking for to protect your property interest? But then also looking at on the custody side, if there's kids involved, does it make sense to do it while they're in school? Would that disrupt them? Or is this something that you can wait towards maybe the beginning of summer and hopefully try to resolve it? And then also going back to where you're filing at, there's a waiting period. Again, going back to North Carolina as an example, it's a year and a day. So there's some jurisdictions that are 2 years. And so what does that look like? And just making sure that you're properly prepared to and incur these additional expenses are going to come along if you are separated, and kind of ironing out what does that look like for not just property and finances and debt, but what are we going to do when if there's kids involved, and what does that custody going to look like? Because what you usually do during the period of separation becomes permanent. It's rare that there's going to be a change unless it's agreed to by the parties. And although a lot of orders say temporary, it is true by the literal sense of it is temporary, meaning temporary until final order. But that temporary usually is the final order. And it all goes back to making sure you hire that right attorney.
Right. I think also with waiting for the other spouse to file, you're just putting yourself behind. So the thinking or the logic of, oh, well, I'll let them do it. I want them to incur the expense. Well, when you get served with a complaint for divorce and discovery requests and a whole bunch of other stuff, you're going to end up hiring an attorney anyway, and they're going to be scrambling to keep up with the deadlines. So you're not doing yourself financially any favors to try and put the onus on the other side. It's going to come right back to you as soon as they do hit the go button, right? So I feel like there's never really a benefit in waiting for the other side. We might as well, we know where the process is going. Let's get the ball rolling and start doing things the right way. We don't need to create a delay or have any other sort of problems. What about hiding information from your attorney? How can that impact your case?
Never a good thing to do. You're hiring an attorney because you want them to be the advocate for you. And if you are not completely transparent in what's going on, it's hard for that attorney to really fully and zealously represent you. Nothing's worse, because I've been in this situation to where I met with a client, they told me everything I asked for, and I go in front of the judge and the other side brings something up that I had no idea about. And it's not a good situation. I mean, for me, I feel silly, but then it's bad for the client because it's, well, why did the client say this, or what's going on? Is the client not being truthful? Then you're starting to question veracity of the client and what else is happening. And I know clients think, oh, I just want to tell you, what I think you want to know. Well, no, I want to know everything, and I'll parse it out as far as what I think is important. Or some clients may say, well, if I tell you everything or I give you everything, you got to review it. I'm going to incur all these costs. Well, I can tell you this, it's a lot. It's better to incur the costs up front than incur what we need to do to potentially repair anything on the back end, if it can even be repairable. And then some clients are just embarrassed. And I get it. On this side of the law, you're airing your dirty laundry. No one likes to do that. And it can be just embarrassing at times, or maybe there is some abuse that's going on. You have to own up to it if it's happening, so your lawyer knows how he or she can best represent you and what makes the best sense as far as, do we settle the case? Do we try the case? Or maybe there's something that we can do to get you into some type of counseling to help repair this situation and then really mitigate the potential damages. So up front, you really just kind of want to just tell everything. And I always go back to the medical. When you go and talk to the doctor, you're airing dirty laundry because you're advising, certain issues that you're experiencing. But you're going to be upfront with your doctor, right? Because they're going to have no idea how to diagnose what's going on or prescribe the right type of treatment program if they're not fully informed. So you want to treat your lawyer the same way. You want to make sure that you're upfront, honest with your attorney.
Yeah. You never want to get into a trial and have your attorney be surprised about something. Some piece of evidence or some sort of testimony comes out and you're sitting there like, what am I supposed to do with this now? That at that point it's going to be too late. And I had a situation actually where a client had been engaging in an adulterous affair, and he had utilized a certain credit card for all of his dates in the hotel rooms and whatever. And at some point he said, oh yeah, well, I do have this other credit card, but I don't want to turn that over. Okay, well, now you've put me into a situation where if you don't turn it over, I'm going to have to withdraw as your attorney because I know that you're intentionally withholding this information. And by the way, the other side is going to figure it out when they send a subpoena to the bank, and they're going to get it anyway. And they're going to get attorney's fees for you trying to obstruct the whole situation. So it's better to just be upfront and say, this is what there is. This is as bad as it gets, right? And now let's deal with it. Now let's figure out how we can get past it. What about a situation where the client is just not prioritizing their children? They're busy, they're going on dates with their new person, or a situation like that. How can that have an impact on their case?
that could probably have one of the most detrimental impacts, especially when that parent wants to spend time with the child and they're off, whether it's with friends or a paramour or whoever it is, but they're ignoring their child or their children. I always advise clients, this is a time where you need to be the most focused on your priorities. And if your priority is your child or your children, then you have to make them a top priority. Everything else can wait. This cannot wait, because the court's going to look at what is the current situation. And if the current situation is that you're going out when the kids are with you, but you're not spending that quality time, the court's going to remove them from you and give you potentially maybe alternating weekends, or maybe even less than that, or supervised visitation, depending upon what the issues are and how old the kids are if they're left home alone. What you're really doing, besides damaging your credibility in your case, is you're allowing the other side to use this against you, and you're substantiating what they're wanting. And you're just giving them everything essentially on a silver platter, saying, oh, here you go. I really just wanted this because I'm trying to cut back on the child support, which may not be the case, but that's what the perception is going to be. And a lot of times in this side of the law, perception can become reality. And so you just want to head that off at the path. Hi, this is Dan Cuneo with I Now Pronounce You Divorced. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.
Thank you for tuning in to our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.